Well, ladies and gentlemen, I'd like to thank you all for giving up your lunch hour on such a beautiful summer's day to hear this talk on New British Constitution, which is also the title of my new book, and by chance there are copies available for sale afterwards at a discount price, and I'm also happy to sign any for no extra charge. But the best thing I think ever said about the British Constitution was said by the Queen. She attended the seminar of one of my colleagues, Peter Hennessy, who's a professor of Queen Mary College. She was a visitor. She was a visitor of Queen Mary College and asked to look around, and she heard the seminar was going on about the British Constitution. She asked if she could sit at the back, and she listened carefully to the discussion. And at the end of it she said, "The British Constitution has always been puzzling and always will be," which you may think is a canonical text, because if she doesn't know about the Constitution, which of us does? She attended another event a few years before that at University College London, where I think she was also the visitor, and she was going round the various stands, and she came across the stand of the lawyers, and she saw one of the books they had edited, which was called, some of you may be familiar with it, it's gone through a number of editions, it was called The Changing Constitution, edited by Geoffrey Joel and Dawn Oliver. And Geoffrey Joel was standing nearby, and she said to him, "Changing, Professor Joel, what changes? I haven't noticed any changes." And he replied, "Well, evolving, ma'am, evolving." And she said, "Yes, but in what direction?" Which I think is a good question. But I think you couldn't now say there haven't been any changes. This was some years ago. I think you couldn't now say there haven't been many changes, because we've seen since 1997 a huge number of changes, which I suggest in my book amount to a new British Constitution. And there are really two themes of the book. The first is that these changes that we've had since 1997 give us, in effect, a new British Constitution, though most of us haven't noticed it. But second, that these changes are insufficient, and that we now need to open up the Constitution much more than it's been opened up in the past. It's still a closed system. And I think it's purely fortuitous, but perhaps I ought to thank people like Nicholas Winterton and Sir Peter Viggers for bringing out the expenses scandal, because I think this emphasises one of the messages of the book, that we have too closed a system, that Westminster is too cut off from the public, and that we need reforms to open it up much more. So there are these two themes. Firstly, that there have been very radical changes since 1997, which we haven't perhaps noticed as much as we ought to have done. And secondly, that these changes are actually insufficient to give us a really satisfactory constitution. Now, until 1997, I think it could reasonably be said that our constitution, by which I mean here our system of government, was what has been called a historic constitution. And what I mean by that was not merely that it's very old, though it is very old, but that it was unplanned, the product of evolution rather than, as it were, human thinking. It just evolved in a way that so many British institutions have been evolved. And it was very difficult to actually discover what it was. If you were to join a tennis club and you pay your subscription, and you then say, "Well, could I please have a look at the rules of the club?" And someone replies to you, "Well, actually, they haven't all been gathered together in any one place. They're the product of a long period of history, and some of them are not written down at all. They're unspoken conventions. You'll pick them up as you go along. And I have to warn you that if you have to ask about the rules, it shows you don't really belong at all to the club." I think you might be a bit upset about that, but you may argue that was what the British Constitution was until 1997. The rules weren't wholly clear. And in this point of view, we differ from almost every other democracy. There are only two other democracies without constitutions brought together in one place, so they are New Zealand and Israel. The British Constitution then, and I think the expenses row brings that out, it was never clear what the rules are. It's based on unspoken conventions, and you may say even nods and winks as well. They're not clear. Someone once said, and this was over 100 years ago now, he said the British system of government is based on tacit understandings. But then he said, but the understandings, unfortunately, are not always understood. And so this is one reason why we never had all this brought together, because there's a sense in which England never really began as a society. Most countries have constitutions when they have a constitutional moment, a revolutionary break with the past, as with the United States when it broke from Britain, or Germany after the war and they had to start again, or France in 1958 when de Gaulle came to power after a coup d'etat and determined to create a new system. Then countries draw up a constitution. They have to start again. The ex-communist countries in Eastern Europe, another good example. But in a sense, we never began in that way. But secondly, it's very difficult to have a constitution if, as in our system, Parliament was sovereign. Now, what it means to say that Parliament is sovereign is that Parliament can do what it likes. And it was once said by an 18th century thinker that Parliament can do anything it likes except turn a man into a woman or a woman into a man. But even that is untrue, because if Parliament says that from the point of view of the law, a man is a woman or a woman a man, then that is actually the case. So Parliament can do anything. Now, if Parliament can do anything, there's no point having a constitution, because the constitution could be summarised in just 8 words. It would be what the Queen in Parliament enacts is law, and no restrictions on the power of Parliament, in effect, the government. And a great French thinker in the 19th century, Alexis de Tocqueville, said that in England, I think he meant in Britain, but in England, the Parliament has an acknowledged right to modify the Constitution, so therefore the Constitution may undergo perpetual change. It does not in reality exist. The Parliament is at once a legislative and constituent assembly. But now we've had, since 1997, over this period of 12 years, we've had a huge number of constitutional reforms, and I tried to work them out. I list them in my book. I listed 15, and you'll be pleased to hear I'm not going to go through the 15, and I think a lot of them are probably very familiar to you. Devolution is one major reform, so that the non-English parts of the United Kingdom now have their own parliaments or assemblies. The Human Rights Act is another very major reform, and you probably read in the newspapers a couple of days ago that the judges said the control orders designed to restrict the freedom of suspected terrorists, that these control orders go against the Human Rights Act. So I don't think anyone would deny the Human Rights Act, for better or worse, had a major effect on British life, on British government. Then the Freedom of Information Act, and I think without the Freedom of Information Act we'd never have known about the expenses scandal, so that too is a very major reform. And then the reform in the position of the Lord Chancellor. He has lost some of his role. He's no longer the Speaker of the Upper House. He's no longer the head of the judiciary. And for the first time, the Lord Chancellor has not even appeared. Jack Straw, Lord Chancellor and Minister of Justice, but he no longer has the roles the previous Lord Chancellor has. And the senior judges are moving out of the House of Lords into the Guildhall. They're much more insulated from politics than they were in the past, in my opinion. So these are all very major reforms. And I think they give us a totally new system, but we haven't noticed it because things move in an evolutionary way, and because we don't have a constitution, we don't actually bring our minds to bear much as we might perhaps on constitutional change. But I think someone falling asleep in 1997 and waking up today would find a totally changed landscape. It's rather like the famous story of Rip Van Winkle, who went to sleep for 20 years in America, and when he went to sleep, he saw a pub nearby called the George, and on it there was a portrait of George III. But when he woke up, it was also called the George, but the portrait there was of George Washington and not of George III. So a lot had changed while he was asleep, and I think if we'd been asleep, we'd have found exactly the same. Now, all these changes, for better or worse, they have, I think, one very important effect, which I think hasn't been underlined as much as it should have been, and that is to limit the power of government. Now, the Human Rights Act very obviously limits the power of government. Some people say in a bad way, because they say it means government can't deal effectively with the threat of terrorism or the problem of asylum seekers because of the Human Rights Act. But whether you think it's a good thing or a bad thing, it does limit the power of government. Devolution limits the power of government because in Scotland, Wales and Northern Ireland, what you might call domestic political affairs, matters like health and housing and education, after all, I suppose they're the matters on which we write to our MPs about, these matters are now out of the hands of Westminster. They are with the Scottish Parliament, the Welsh Assembly, the Northern Ireland Assembly, so government's limited there as well. And then we've seen a major reform of the House of Lords, which, whether intended or not, it may be unintended, but that's also had the effect of limiting the power of government. Because before this reform in 1999, the Lords was composed of 2/3 hereditary peers, who tended mostly to be Conservative. So the Conservatives always had a majority, whichever party was in power in the House of Commons. And this meant in practice that the Lords didn't use its powers very much, because they realised they didn't in fact have much legitimacy. But now, with all but 92 of the hereditary powers removed, no single party has an overall majority in the House of Lords. In fact, the largest party in the Lords, for the first time in its history, is now the Labour Party. And the second largest group are the group of crossbench peers, who don't belong to any party, independents. And the Conservatives are now the third largest group. But no one party has an overall majority, and it seems to be accepted that no single party should ever again have an overall majority in the Lords. Now, this has an important consequence, because, of course, governments normally have an overall majority in the Commons. They can normally rely on getting their legislation through the Commons. But they can't on getting their legislation through the Lords. They actually have to win the argument, if you like. They have to win over the support, usually, of the crossbench peers or the Liberal Democrat peers, who are, as it were, the centre grouping. You can't win by just getting the votes of the Labour peers. There aren't enough of them. They have a majority, but not an overall majority. So that's another restriction on the power of government. May not have been intended. We don't know. So I think before 1997, governments could say, reasonably, once we produce some legislation, we can rely on getting it through. Now they have to ask themselves a lot of different questions. They have to ask first, can we get it through the upper house? Can we get it through the Lords? Then they have to say, will this apply in Scotland, Wales and Northern Ireland? Perhaps it doesn't. Some of you may remember that long ago in 1997, Tony Blair produced 5 policy pledges. Now, 2 of those pledges were to reduce class sizes and to reduce waiting lists in the National Health Service. Now, those policies are outside his power with regard to Scotland, Wales and Northern Ireland. It's up to the bodies there what they do about class sizes or National Health Service waiting lists. And so I think this is a further restriction on the power of government. And you'll probably know that if you're a student, you don't pay fees in Scotland in the way that you do in England. Higher education is free in Scotland. There's a very amusing anecdote, which is in Paddy Ashdown's diaries about that Blair berated Ashdown because the Liberals in Scotland were pressing for the abolition of student fees in Scotland. And Blair said, you can't have a different system in Scotland from the rest of the country. And Ashdown said, well, in that case, you shouldn't have given devolution to Scotland. And Blair said, what do you mean? And he said, well, you've devolved that power to the Scottish Parliament. You make yourself ridiculous if the first time they try and use it, you say they can't. And Blair replied laughingly, well, perhaps there's a bit of a downside to all this devolution stuff. I think he'd assumed that the Scottish Parliament and the Welsh Assembly and the Northern Ireland Assembly would do exactly the same as Westminster, a Labour government at Westminster. But if they did, there's no point setting them up. The only point setting them up is they should do different things. But anyway, it's another hurdle that governments face in getting policies through. It applies only to England. And if you take areas like health, education, transport and so on, the government at Westminster is no longer a United Kingdom government, it's an English government, a government solely for England. There's a major change that the non-English parts of the United Kingdom are now governed quite differently. So that's a further point. And then they have to say, can we get it through the Lords, as I've said. But of course there's a further limitation which was there from a long time ago, from 1973 when we joined the European Union. Governments have to ask themselves, is this compatible with European Union legislation? Because, for example, if to take an extreme example, a government wanted to set up customs duties against French goods, they couldn't, it's illegal. And the European Court of Justice would say it's completely out of turn, it's illegal, you can't do that. And there are all sorts of things the British government might want to do that it can't in fact do because of the European Union. So a government, there's a kind of cliche about governments in a way that people say it's an elective dictatorship. That was first said by Lord Hailsham, the Conservative Lord Chancellor, in the 1970s. Well, whether that's true or not, government today is much less of an elective dictatorship, I think, as a result of these reforms than it was before. Government is much more limited than it was, and I think that's one main consequence, one main effect of all these constitutional reforms. If you go into every single one, it has the effect of limiting the powers of government, and this seems to be a major change. We now have a more limited system of government. Now I want briefly to say something more about the Human Rights Act, because the Human Rights Act, as I suspect you know, it doesn't actually give judges the right to strike down legislation they don't agree with. It's not like the American Supreme Court, for example, where if legislation is thought by the Supreme Court to go against the Constitution, they can simply strike it down. They say this goes against, for example, the Equal Protection Clause or freedom of speech or whatever it is. They can't do that, and this has been perhaps misreported in the press. The decision about control orders, for example, is not really a decision. All the judges can do is issue a declaration of incompatibility. They can make a statement. A declaration is no more than a statement. It's then up to Parliament or government whether they're going to do anything about it, whether they're going to alter the law, which they have discretion to do. Now, so far, it's fair to say, government and Parliament have, on every occasion, about 20 occasions since the Human Rights Act, on every occasion they've altered the law, but they don't have to do so. It's entirely up to them whether they do it. Now, the Human Rights Act then has a double impact, as it were. On the one hand, it preserves parliamentary sovereignty. It's still up to Parliament to decide whether or not to change the law. But on the other hand, it seems to give the judges much more influence at the very least. And you've got a conflict, really, between two principles. The principle of parliamentary sovereignty, which means Parliament can do what it likes, and the principle of the rule of law, which means Parliament can't do anything which goes against the rule of law. And I think we'd all accept that as a moral principle. For example, if Parliament said all red-headed people are to be executed next Monday, I think we'd all say, well, and no doubt legally Parliament can do that, but morally it can't. It goes against the rule of law. And I once asked a very senior judge, now what happens if these two principles conflict, which they can easily do, the sovereignty of Parliament and the rule of law? And the senior judge smiled at me and said, well, that's a question that ought not to be asked. And you can see the point. This is a very British compromise. Try not to ask this question. But people are beginning to ask it because some people are saying, well, the judges are taking too much power upon themselves. Well, the judges are saying that government is too restrictive of civil liberties in a time of danger, that they should be more careful about civil liberties. But there's a conflict also between two understandings of the Constitution. The first is the traditional one, that it's based on parliamentary sovereignty. And the second, which we're moving towards, I think, is it's the rule of law dependent upon the judges deciding what is constitutional and what isn't constitutional. And I think we're moving towards the second, which is what I would call a constitutional state, where it isn't Parliament that decides what's constitutional, but the judges, which you have in most other countries. Suppose you had a law which went flagrantly against any notion of the rule of law. Would you expect the judges to apply it or not? Now, there's a very interesting analogy here from the European Union. There's a famous case which will be familiar to those of you who are lawyers, so if there are lawyers in the audience, forgive me for repeating it, but it's a famous case called the Factor-Tame case in 1990. And that came about in the following way. Parliament had passed a Merchant Shipping Act which restricted the fishing rights of foreigners in British territorial waters. And some Spanish fishermen said this was against the European Union's common fisheries policy. And the European Court of Justice agreed with them. They said it's against European law. Now, what were the British courts to do? Because you see, the European courts say the European Union is a superior legal system to the British legal system, or the French, or the German, or whatever, and so we say what is legal and what isn't. What do the British courts do? Are they to follow that rule, or are they to follow the rule of the sovereignty of Parliament, which says Parliament can do what it likes? Well, the British courts did something quite revolutionary. They said they would disapply those portions of the Merchant Shipping Act which restricted the rights of Spanish fishermen. So they were, for the first time ever, restricting the rights of Parliament. Now, you may say, if they can restrict the rights of Parliament in relation to the European Union, why not in relation to human rights? Suppose Parliament were to pass an act denying people access to the courts, for example. Suppose they were to pass, as they nearly did a few years ago, an act saying that asylum seekers who were denied permission to stay here should not be able to appeal to the courts. Now, might the judges then disapply that legislation, take no notice of it? I think they might. And I think we're moving towards a situation where our civil liberties are coming to be guarded not just by Parliament, but also by the judges. And I want to quote what Lord Steyn, a retired law lord, said in a recent case. He said, "In exceptional circumstances involving an attempt to abolish judicial review of the ordinary role of the courts, a new Supreme Court may have to consider whether this is a constitutional fundamental which even a sovereign Parliament, acting at the behest of a complacent House of Commons, cannot abolish." Even more strongly, another law lord, Lord Hope, said this: "Parliamentary sovereignty is no longer, if it ever was, absolute. It is not uncontrolled. It is no longer right to admit that its freedom to legislate allows of no qualification whatsoever. Step by step, gradually but surely, the English principle of the absolute legislative sovereignty of Parliament is being qualified." And then he said, "The rule of law enforced by the courts is the ultimate controlling actor on which our Constitution is based." And that is one of the central themes of my book, that we are moving away from parliamentary sovereignty to control by the courts of the rule of law. That's a central part of the new Constitution. Now, there's one other restriction on government which I haven't so far mentioned, and that is the referendum. Now, I think if the referendum had never been invented, we might well now be in the Eurozone, members of the Eurozone, because the Blair government favoured that policy. Tony Blair said that many times when he became Prime Minister. But he'd been forced, as a result of political pressure, to promise that we wouldn't enter the Eurozone without a referendum. And he decided not to call a referendum for the very good reason that not a single opinion poll on the euro has ever shown a majority in favour of Britain joining, so it's very likely that a referendum would be lost. And that's a clear restriction on government. Before the referendum had been invented, if you like, governments could simply join the euro without needing to seek the approval of the people. But now they can't do that. And governments have also promised that they won't change the electoral system without a referendum, and that is again a restriction on government. It may be that Gordon Brown these days would like to change the electoral system to keep the Labour Party in office, but I mean, he can't do that without a referendum. It's a great restriction on the power of government. And this is a different restriction from the others because, of course, it gives some power to the people. The other restrictions are restrictions of lawyers or other legislative bodies. But this restriction is, if you like, a popular restriction. It gives us the power to limit government. But it gives us a very limited power because, after all, it's governments who decide whether to promise a referendum and when to have one. The Labour Party promised some time ago to have a referendum on electoral reform, but they didn't say when they were going to have it. And many people who are in favour of change, the Liberals, for example, said it's about time you had it. You made this promise a few years ago. But I think there's a difference between a promise and a politician's promise. I think they're different sorts of things. But this really sums up the first theme of my book. That now it's no longer right to say that our constitution is purely the product of evolution and unplanned and historic. It's something deliberately planned and designed by human beings, by a government. For better or worse, you may think it's a good new system, bad new system, but it's deliberately designed and planned there. And we're moving, I think, in a very tortuous, typically British piecemeal way towards having a written constitution. And Gordon Brown has said there ought to be a debate on that. We ought to think more carefully about that. We're doing this in a piecemeal way because there's no real political will to do more, I think, and no consensus on what the end point should be, no real agreement. Perhaps we haven't had the debate yet. But despite all this, and despite the fact there's been a dispersal of power of a quite considerable degree, it's reasonable to say that this has made little impact on most people, and it certainly hasn't cured the malaise in the political system, which is, I think, very strong. And I think this malaise was there before the expenses scandal. I think the expenses scandal has highlighted it. And this malaise was brought home to me in a very stark fashion when something happened to me that I suspect has not happened to anyone in the audience. It was shortly before the 2005 election, and I was rung up by the editor of Cosmopolitan. And I thought, well, perhaps they want my photo on the front of the magazine, but it wasn't that. And they said they were very worried at the fact that so few young women aged between 18 and 24 voted in general elections. And the figure for 2001, which is 33%, is 1/3 of young women were voting. And they said, what could be done about it? And very difficult to think of a rapid answer on the phone, but I gave what I suppose is a typical academic's answer. I said, why don't you have interviews with the three party leaders on issues of interest to young women, then publish the results, and perhaps turnout will improve. Well, they did that, but needless to say, turnout did not improve, exactly the same. And the 18 to 24-year-olds, as a whole, 39% vote, but 33% of young women, many more young men than young women actually vote in elections. And if you look at overall turnout in the last election, it was 62%, and the election before 58%. It's the lowest in Britain since universal suffrage. So whether you think these reforms are good or not, whatever your views on them, they haven't excited interest in the political system. They haven't affected, if you like, the malaise of participation or non-participation. And that is the second theme of the book, of what's to be done about that. But if you look at these reforms, if you take someone living in England and ask what effect have they had on me? If you live in England, you may say, well, it's all very well, the Scots can have devolution if they want it, but we don't want it here. And difficult to say in the southeast, we live in a region, we don't want regional devolution or an English parliament. The last thing we want is another set of politicians with a new body and bureaucracy and so on. And I think it was John Major who once said, if the answer's more politicians, you're asking the wrong question. We don't want that. And then they say, well, the Human Rights Act may be a good thing, but we hope never to use it. We want to keep out of the hands of lawyers if we can, and not to have to go to court. Maybe a good thing. But what effect has it really had on me living in England? Answer, none. And I think the reason for this is the first, if you like, tranche of constitutional reforms has redistributed power, it's dispersed power, but between different members of the political and judicial elite. It's redistributed power between the political elite in London and a different political elite in Edinburgh, in Cardiff and in Belfast, and also at, with the mayor, through the Mayor of London. It's redistributed power to members of the House of Lords and to the judges. But it's redistributed power, if you like, sideways. You can say it's as if the officer class is deciding how to divide up the spoils. But it hasn't redistributed power downwards. And that, I think, is the central weakness of the reforms. And this is, in the last part of my book, I say that this is one main reason for the disenchantment with politics. And I think the expenses crisis has reinforced that view. Firstly, it's shown how out of touch MPs are with the public, and that Westminster is very much of a closed system. You might say a house without windows where people aren't looking out at what the popular attitudes are, and I think many people feel that about Westminster. It's very, very out of touch with public opinion on expenses issues, for example. And secondly, I think the expenses crisis has undermined the authority of members of Parliament, because people say, well, MPs have the authority to legislate because they have certain superior qualities. But if they don't have these superior qualities, if they're no better than the rest of us, or indeed much worse than most of us, then what is their authority to legislate? Can't we, in fact, legislate more for ourselves, make more decisions for ourselves? And Gordon Brown made a very good comment about this as long ago as 1992. I mean, he's taken some time to act on it, I think, but he made a good comment. He said, in the past, he said, people voted for the Labour Party as an agent of change, but now they want to be agents of change themselves. I think that's a very perceptive comment. They don't want to rely anymore, as much as they did at least, on politicians and members of the elite to make decisions for them. And we have to remember the tremendous social and educational changes of the post-war period have given us a much less deferential electorate than we used to have, rather. And people are no longer content simply to vote in general elections once in 5 years and leave it at that. They want to have much more impact on decision-making. And I think that's a very crucial feature in our modern degree of disenchantment. I think there's a great danger in looking back and thinking of a golden age of politics. Looking at the past, I reviewed a book a little while ago on post-war Britain, and the level of political knowledge at that time was absolutely pitiful. There was a survey undertaken in 1949 asking people if they could name a single British colony, and 49% of those surveyed could not. And then there was a survey in 1950 of the Greenwich constituency, and this was before the party of the MP was put on the ballot paper. It just had the name, Blogg, Smith, whatever. It didn't say Labour Party, Conservative, whatever. And they asked people what party the MP for Greenwich belonged to. This was in the general election campaign, and 50% of the electorate did not know. So we must be very careful about romanticising the past. The truth is that people are now much more politically educated than they ever were, and partly for that reason, much less deferential than they were. They want to play a much wider part in making political decisions themselves, rather than simply voting every 4 or 5 years and leaving it to wiser people than themselves. And what I discussed in the last part of my book are ways to open up the system. And though I say it myself, I think this has been given even more force by the expenses scandal. It was, of course, written before the expenses scandal. And the first of the 4 things I suggest is that there should be primary elections for MPs, so that they're no longer chosen by small unrepresentative cliques of voters. Party membership is much smaller than it was. In the Labour Party, under 200,000, I suspect about 150,000. Conservatives about 250,000. And it's a familiar point that the total membership of the Royal Society for the Protection of Birds or the National Trust is more than that of all the political parties put together. See, people are joining organisations but not political parties. And it's an important point that I try to make, that the democratic spirit in this country is very healthy, but the democratic institutions don't reflect that health. There's something wrong with our institutions. Now, last year in the election for the Mayor of London, David Cameron, I think rather bravely, put forward the idea, and indeed it was carried into effect, of an open primary for the Conservative candidate. An open primary meant that anyone could vote, choose between the candidates. It didn't have to be Conservative members or supporters. Any elector could vote. And people said that would work badly, that people who didn't belong to the Conservative Party would deliberately vote for the worst candidate in order to damage the Conservatives. Well, I mean, some of you may say, well, they did. They got Boris Johnson. But I mean, I think that would be an unfair point, because Boris Johnson, whatever your views, was obviously the ablest of the Conservative candidates. But primary elections, I think, are very important. It's not an accident, I think, that many of the worst offenders on expenses were in safe seats, where they've been chosen by small groups of party members and couldn't be challenged. If you look at one of the worst offenders, who's Nicholas Winterton from Macclesfield, who's not standing again, he's only the second MP who sat for Macclesfield since 1945. There have been two Conservative MPs, a very safe seat. And similarly, a seat like Durham would be safe for Labour. I mean, you could put a donkey up there and call it Labour and win the seat. So it's in the safe seats that you get the worst problems. And the second proposal that I mentioned to open up the system is to get an electoral system that allows people to choose between candidates of the same party as well as between parties. The single transferable vote system is one such system. There are others. We don't want, well, the one thing we don't want is a closed party list system of the kind we have in the European elections, which I think, frankly, has helped the BNP. People sometimes talk as if proportional representation is just the name of one particular system, but it's actually a generic term for a wide range of different systems with different properties. And although you can easily, I'm sure I could drive you all out of the room fairly quickly by talking about the differences between them, or the additional member, or the don't quota, or so on. I'm not going to do that, but I mean, it is, I think, important to understand the differences between the various systems to some extent, but you'll be relieved to hear I'm not going to do that today. The third proposal that I mentioned is that there should be a much greater degree of direct democracy, not just referendums, but initiatives. And the difference between the two is that a referendum is triggered by government, but an initiative is triggered by the people. And we have an example of that already. It was in the 2000 Local Government Act. And in that act, any 5% of local electors in any local authority area could require a referendum on a directly elected mayor. And the reason for that was the government had found that most councillors did not like the idea of a directly elected mayor, but many people were actually in favour of it. The councillors thought it would undermine their position, but many ordinary voters were in favour of it for one reason or another. And it's for this reason that 5% could trigger it off. And I remember signing such a petition in Oxford, where I live. We got the referendum, but sadly, or in my view sadly, it was lost. The proposal for a mayor was defeated. But still, we were able to get it on the agenda. Now, this is a revolutionary innovation in British government, because it does give people the right to trigger a referendum on their own without relying on government. They can do it against the wishes of government, if you like. And if you may say, well, if people can do it on the issue of directly elected mayors, why not on other issues as well? Why not, for example, on the organisation of schools in an area? Why shouldn't 5% of electors be able to trigger a referendum, shall we say, that they want grammar schools or sixth form colleges or whatever it is? What about even the organisation of the National Health Service in their area, or the size of the local authority budget? Why shouldn't we start to extend that principle so that people themselves can trigger legislative initiatives? And associated with that is a proposal that is not in the book, and I think it probably should be, but it occurred to me after I was reviewing a book, which at first sight seemed a bit odd. It said that some of our legislators could be chosen by lot. And I wonder why not. I mean, suppose in a local authority you had a small number of members, say 5 councillors, chosen from a list of volunteers randomly. They wouldn't then be party people, they'd be ordinary citizens playing their part. What about a few people chosen by lot for a National Health Service board? Now, there's a very interesting experiment on those lines in Canada, which I do discuss, and that's the last of my proposals. In the provinces of British Columbia and Ontario, the provincial government said they were going to elect a citizens' convention by lot, and that citizens' convention was to recommend a new electoral system for the province, and whatever their recommendation, it would be put to referendum. So it wouldn't be just a talking shop, it'd be put to referendum. Now, they chose 1 male and 1 female from every constituency in the province, and people had the opportunity, when their names were put out of the hat, saying, I'm not interested, because it meant giving up 52 weekends, it lasts for a year, with no pay other than expenses, I mean proper expenses, not MP's expenses, expenses, and child care where necessary and so on. But 1 male and 1 female from every constituency. And the remarkable thing about both of these conventions is how effectively they worked. That the ordinary people concerned, they took evidence from experts, they studied papers, a lot of work, they gave up 52 weekends, and they produced excellent reports which were put to referendum. And British Columbia is repeating it this year because the referendum was defeated for their proposal. So there's another one this year in British Columbia. We don't yet know the outcome, but it does show that many tend to underestimate the ability of ordinary voters in a democracy to make decisions for themselves on complex matters without relying on politicians. And a lot of us might say at first sight, well, an electoral system is far too complicated, you better leave it to those at the top. But actually, that isn't the case. And Canada shows this works perfectly well. And the more you bring people into government to make decisions, the more, I think, of an educated electorate you have, and a sophisticated electorate. So those are the 4 proposals with which I conclude the book, and which suggest that what needs to be done now is a second phase of constitutional reform. The first phase dispersed power between elites, helped to control power. That, I think, was very valuable. But the second phase needs to open up the system, to open up power, if you like, and disperse it not sideways, but downwards. And I think this is particularly difficult in some ways in the British Constitution, because the whole principle of parliamentary sovereignty implies a top-down system, that the Queen in Parliament governs, whereas so many constitutions, like the American, for example, begin with the words, we the people, not the Queen in Parliament, but we the people. And you may say, if you live in a democracy, you should be governed by we the people, not by the Queen in Parliament. And of course our system, it derives from a time before Britain, long before Britain was democratic. The Queen in Parliament, from the 17th century battles over sovereignty, the Queen in Parliament. So we have a top-down system derived from the past. And I think that top-down system is really incongruent, inconsistent, if you like, contradicts the social and political pressures of the age, which are a much greater degree of popular power, people wanting to take power for themselves, to make decisions themselves. So I think we're faced with a very deep-seated conflict between our inherited traditional constitutional forms, which are of a top-down nature, and these forces, if you like, coming up from below. And I think the next phase of constitutional reform has to resolve that contradiction. I think it's one of the most important problems that governments face. And I think in a way the expenses crisis has only underlined the importance of that problem. Well, thank you for giving me your time, and I think we can now spend a little time, we've got to 1:30, in questions and criticism and so on. Thank you.